Ji, Assalamu alaikum everyone. Welcome to the 31st Lahore Policy Exchange, which is usually organized, and I think this time also by the CDPR, if I'm not wrong. And the topic today is protecting women's legal rights in marriage. We are going to specifically talk about the nikahnama, how it is filled, the ramifications felt by women when it is not filled out properly, and the policy implications of that. We have two speakers today. One is Dr. Kate Wyborny. She's a postdoctoral associate in the Department of Economics at Duke University, for those of you who don't know her. She's also a project lead in the project Institutional Reforms and Women's De facto Rights at SERB. Kate has worked actively on research and policy outreach on foreign trade, foreign aid, trade and development of the Center for Global Development and the Carnegie Endowment for International Peace in Washington, D.C. She has a DPhil from the Department of Economics at the University of Oxford. I have known Kate quite closely in the recent past and worked closely with her, and I think she's one of your very rare researchers who just does the work and does the work and doesn't want any credit for it. So I think we need to give her a hand, for that. And a very rigorous researcher. We also have with us Mr. Sohail Varaj. He's a women's rights activist, a freelance researcher, a writer, and a trainer. I think Sohail has spent his entire life in activism, in research, in unearthing issues and working on them, highlighting issues, to the point where it can be taken up by policymakers. Again, a person that I worked with for a very long time. And that is when he was working at Shirkatgah, where he was Pakistan's. What were you at Shirkatgah, Sohail? Okay. Policy, yeah.
We know each other well.
Well, that's enough. No, but I want the others to know that. Okay. So,
maybe in future.
Yes, definitely in future. We are working together, in fact, at the moment also trying to understand the redressal mechanisms for violence against women, specifically with reference to two case studies, one on a gender-based violence court in Punjab, and the other one is Violence Against Women Center in Punjab. He has an LLM from Warwick University in Law and Development. So here we have Sohail also. I am going to ask Kate to talk about the project on nikah registrars and the evaluation project on training of nikah registrars that the Punjab Commission on the Status of Women did. And Kate is actually going to talk about it in a broader perspective of institutional reform. Kate, if you don't, and de facto women's rights. Thanks, Kate.
Thank you so much for coming and braving the traffic on Mall Road today. We really appreciate having such a great group, and I think there's a sort of a mixture. So how many lawyers do we have in the room? Can you lawyers raise your hands? And sort of economists or impact evaluation-y people who are more my tribe? Okay, so we've got about a 50-50 mix, so that's nice. Fawzia didn't actually get an introduction, so I'm going to briefly introduce her. So Ms. Fawzia Vickar is chairing the session today, and she's been so as you may have seen on the program, she's the chair of the Punjab Commission on the Status of Women and has been since its inception, I think, just a few years ago, an absolute force for women's rights in the province. And it's from when I first had an opportunity to visit her in the new office at that time of the commission a few years back. I think at that time there was only one other permanent staff person, and since that time the Commission has done, under her leadership, a number of amazingly impressive initiatives, including the one that we're going to talk about today. So really thinking on a very broad scale about how to deal with some of these really challenging issues in the province. So this is a collaboration between our team at Duke and SERP and PCSW. So we have my colleague Erica Field and myself at Duke, and here at SERP, Hana Zahir, Mehroz, and Hassan are also joining the session today, and we really appreciate funding for this research from DFID, EDI, and the JPAL Governance Initiative. It's okay, I'll advance it, thanks a lot. So the lawyers in the room will have seen these a lot, and anybody here who got married here probably has seen one of these as well. I include this slide in here for an international audience as well, to motivate the fact that the nikahnama is, for many women, the most important document that they will sign in their lifetime. And yet, in a huge number of cases, nobody tells them what's going to be in it. Neither asks them what they want to be filled in it, neither even by the time that they sign it. They're just, in many cases, just asked to sign the form without even knowing what it is that they're agreeing to, other than the fact that they're agreeing to get married. So there are a number of reasons for this. Clearly, this is this fact is a result of a number of kind of interrelated constraints in the community. But the project that we're talking about today focuses on the marriage registrars who play one of the important roles in determining what's going to go in the terms of this nikahnama, which have implications for the woman's finances, for her rights to divorce, for what will happen in terms of the child care and custody in case of divorce, and so forth. So this is data from about 16,000 marriage registrars, where we asked them, how often do you advise the people whose marriages you're registering about what they should fill in those key terms of the nikahnama? So how much should be the dowry, how much, whether or not the woman should get the delegated right to divorce, and so forth. And almost half of them say that they either always or very often advise the family on how to fill those key terms. And in many cases, they're actually filling it for the family as well. So the marriage registrar has a lot of potential influence on these terms of the marriage. So this is the same subset of the registrars whom we surveyed on the phone. We've asked them, the last time you conducted a marriage, did you advise the family to give the bride the delegated right of divorce, to not give her the right of delegated divorce, or did you not talk about it? And this is just for the one most recent marriage that they registered. About a quarter of them say that they advised the family to give the right, and another quarter say they advised the opposite. So their personal opinion, their knowledge and beliefs really makes a difference in what ends up happening in these marriages. So the actual terms of the marriage are a result of a negotiation, in principle between the bride and groom, in reality between the families of the bride and groom, and in reality also it's become sort of a three-way negotiation with the marriage registrar as well in many cases. So the registrars, we think about influencing the outcomes in three ways. One is that they often are going to play a really important role in just telling the parties what are the options that are on the table. So what does this section of the contract even mean? If I tick this box here, what does that imply for the future? Many people are not going to understand this without this kind of guidance, and they're looking to the registrar to understand what they should fill. So they have an informational role. Secondly, as I've just been motivating with the data, they're advising parties on what they should fill. So the first is just, here's what the options are. Let me explain to you. You can choose to give the right of delegated divorce or not to, for example. The second is, I think you should give the right of delegated divorce, or I think you should not. And the third is by actually refusing to execute a contract. So actually deciding, yes, I'm going to do this, or no, I'm not going to do it. I'm going to override what the parties want to do or not want to do. So for example, marriage registrars could decide when a family comes to them and says, we want to marry our daughter off, and and the registrar realizes that she's underage. He could decide, he plays a role in securing women's rights or effectively enforcing the law by deciding whether or not to comply with that request or to say no. The same thing can happen in the case of elopement. He may say, well, look, you don't have the agreement of your parents to get married, therefore I'm not going to actually carry out this marriage and register it, even though the parents' permission is not technically required. And this is one of the kind of key provisions that sort of motivated this project. he may actually just override, he may agree to go ahead and carry out a marriage, but then make his own edits directly into the contract. So for example, he may cross out the section that even asks, do you want the right of delegated divorce to go to the woman or not? Is everybody already familiar? I've been assuming that people are familiar with what I mean when I say delegated divorce, but okay, so by default, under the law, a husband can initiate a divorce unilaterally. Like the husband can say, I want to divorce my wife. The wife doesn't by default have that right. She has to go through a more complex process called khula. If we tick the box when we get married saying that the wife is going to get the delegated right of divorce, it means that the wife can initiate the divorce in the same way that the husband can. So it puts them on an equal footing as far as initiating the divorce in the same way. So these marriage registrars, who I should have said, I think I took out that slide and should have put it back in, but about 75% of these registrars are also imam masjid, so many of them are basically playing all of these roles. They're advising the community in general, carrying out basically officiating the wedding, actually being the one who is the master of ceremonies in a religious sense, and also registering it with the Union Council office. They're clearly really important in terms of making an impact on whether women get access to the rights that they have on paper legally. And yet, before this initiative by PCSW, over 90% of them had never received any formal training on those rights. So these are the guys that are supposed to be enforcing the law, but many of them did not know what the law even said. So this is a baseline test before training is carried out, and you see that about half of the participants got less than a quarter of the questions right. So PCSW engaged on this extremely ambitious initiative to carry out training across the province, which is intended to reach all of the marriage registrars in the province. It's covered, as you can see, I think that it's a little light here so you can't see the outline of the top of Punjab here. It's covered a large part of the province so far, and it's still ongoing, with the idea being that the last phase in North Punjab is intended to happen over the next few months. So far we're talking about a number, I think, in the range of 15 or 20,000 people who've been trained so far, trained to date. It's really 22,000, 24,000. Those extra two didn't happen in the last couple minutes. I just didn't have the numbers up to date. So it's an extremely ambitious initiative. The emphasis of the training is to ensure that the registrars, who are, as registrars, even though they're not full-time government employees, they are government officials, they are public officials, and they have a legal duty to ensure that women know and receive the rights that they have under the law, including age of marriage, the actual right to consent to a marriage or decide not to go through with it, the financial terms and the divorce rights that are being filled in that form. And the training also emphasizes the punishments that could be applied to registrars who violate the rules in one way or another. Did you have something you wanted to say? No, you just... So we're partnering with PCSW to do a study and an impact evaluation of the training. It's intending to answer the following kind of broader questions. So the first is, can the government, can the state, in the form of PCSW, through this sort of training initiative, and I should have said that this is a partnership between PCSW and the local government department, increase local officials' compliance with the law that's written on paper, the de jure law, to protect women's rights, and thus ensure that they are followed de facto. If so, what are the mechanisms through which that's most effective? Is it through the threat of punishment? Is it through just making sure that they actually know what the law says? Is it through shifting of the social norms by exposing them to a discussion about this that they might not have had otherwise? And ultimately, the project will look at how these changes affect women's actual access to the rights and their well-being and the well-being of their families. So as a result of the collaboration between PCSW and SERP, we've managed together to kind of achieve a schedule through which the training is rolled out across the province. That part is all PCSW's work, but we've worked together on randomizing part of the order of the rollout of the training. So the benefit of this is that we can separate out the trend over time. Like, it might be the case that things are just changing over time in some places and not in others. The fact that we randomize the order means that we can separate out time trends and differences between places that would have happened anyway from the actual impact of the training. So we can be extremely sure that impacts that we observe in this study are because of the training. Without the training, they wouldn't have happened. So in a given union council, registrars from a given union council are invited to participate in the training on a particular day, which is set according to this plan. And then couples who got married in that union council before and after the registrars in that union council got invited to training, they're being compared. Then, even though the training happens over a relatively short period of time relative to the length of a marriage, we can look at the long-term impact of the training on these couples and their families by going back to, say, a couple who got married here just before the training happened in this union council and a couple who got married here just after the training happened in this union council. So in the study, we're looking at a number of key outcomes of interest. The first, and so we can think about this as sort of following a causal chain from the training intervention all the way down to the things that we all really care about in terms of women's rights and their well-being. The first is just that the registrars should effectively understand the law better, have better knowledge as a result of the training. So we're getting at that through a pre-post test that PCSW collects during the training sessions, as well as through a phone survey, which we do separately, so we can catch also people that didn't attend or didn't fill the form if they came. The second is, okay, they may have new information or have new beliefs, but do they actually change anything that they're doing? Do they change the advice that they're giving? Or do they change the way that they fill the form or how they talk to the family on the day of the marriage? So we're getting at that by, again, through different questions in the phone survey, and also by directly observing marriage contracts and nikahnamas and the terms that are filled in them. If that happens, then what we're hoping is that women, as a result, have better access to their legal rights. By that, I mean things like they may be informed before they sign or hopefully even consulted about what it is that they're signing and what should go in the contract. And that is still to be collected, this data, from a household survey. So I'll talk more about that towards the end. And then I think the final point, which is sort of implied by this, is that ultimately we'll see whether the women had a different experience on the day of the wedding, and if they do, then how does that affect their well-being, in the sense that if they have more secure rights to get out of the marriage if it turns bad, does that change the way that they relate to the rest of their family? Does that change whether they're deciding to, for example, work outside the home and feel comfortable kind of asserting that if they have this better legal protection? Okay, so we are still collecting bits and pieces of this data. So what we're showing today are preliminary results, but we have it's a fairly large sample size, but there's sort of more happening. We're expecting the training to be continuing over the next few months in the North Punjab and so on. So you should treat all of this as preliminary. But overall, we see a substantial and statistically significant increase in knowledge across the tested areas, tested knowledge areas as a result of the training. So all of the graphs I'm going to show now have these blue and red bars, where blue are the levels for people who've not yet been trained according to the plan, and red are the levels for people who have been trained according to the plan. So as a result, but these are all for the impact evaluation team in the room. These are all coefficient estimates from our RCT regressions. So we see that overall there's quite a large increase in knowledge about the law and about the issues that are relevant that they're expected to know as a part of their work in this field. And specifically, there's a number of knowledge areas that are driving this that we think are really important. So for example, we see an increase from about 65% of those who haven't yet been trained knowing about what kind of penalty they might be subject to for underage marriage, to almost 100%. So there's more awareness of the fact that they can be held responsible for these kinds of things. Same sort of thing for forced marriage. So this idea that the marriage registrar has some responsibility to do what he can, do some due diligence to make sure that the woman has actually consented. We see a big gains in that. There's also gains in terms of better understanding of some of the financial implications of the terms of the contracts that they are helping people fill in. So about 70% of, this is maybe like 65 to 70% of those who haven't yet been trained getting the correct answer on who owns the gifts that are given to the bride at the time of the wedding, which could be quite a substantial amount of wealth, especially for a not very wealthy family, and a significant increase to something like 80% of them getting the correct answer, having been trained. We also ask them in this phone survey about their intent to practice. So what do you intend to do in the future? Now these things can definitely be over-reported. So we know that, once they're aware that that they're kind of being requested to make these changes in their behavior, they may say, oh yes, I'm going to do this. And so we should take these numbers a little bit with a grain of salt, but at least I would say they're a necessary, if not sufficient, condition for change. So we would hope to see that these things improve, and then we'll go back to see if they actually improved according to other people who don't have this sort of reporting bias. So we see a massive increase in whether the registrar says that he plans to advise more often in the future on how to fill out the marriage contract. So I said at the beginning that they're very often advising, and the training is actually leading them to at least say that they plan to advise more. Perhaps now that we've kind of made it salient to them that the contract has extremely serious implications and they have responsibilities if it's not, that they can be held accountable if it's not done properly. We also see a very large and statistically significant impact on whether they say that they plan to give the right of, plan to advise families to give the right of delegated divorce. So pre-training, about 40% of them say that they would advise families to give that right. This may be a somewhat inflated number, but we see it increasing dramatically up to about 60% as a result of the training. And this is one I think that, for me, seems to really kind of hit at the heart of the matter, which is whether or not the bride knows what she's signing. Such a basic and important thing. Before the training, about 30% say that they intend to check for the next nikahnama that they officiate or register, that they intend to check it. And when they're trained, that number jumps up to over 60%. So the question will be in the future, can we observe whether that's actually changing or not? We've now started to gather, as I mentioned, data directly from marriage contracts, and so far we've done this in Lahore district only, but we hope to continue this in other areas that we're trained in other parts of the province soon. But one thing that we've seen, which is quite exciting, is that we do see a reduction in the actual cases where the delegated right of divorce is crossed out in the contract. So the crossing out of this section implies that often it's not, we don't know for sure because we only see the contract, but if we see the contract with that section crossed out, it often means that the registrar himself decided this isn't a relevant question. I'm overriding this decision. It's not up to the families. This is something I don't believe in. And we see a significant decrease in that happening in the areas where the training has happened after they've been trained. Okay, so the marriage registrars, as I mentioned at the beginning, are really only one part of a much bigger puzzle that sort of comes together to sort of determine whether a woman actually gets access in practice to the rights she has on paper in the law. One of the things that we're exploring in the future, which builds on work that PCSW has already been doing, so, sorry, I should say, So one of the things that we're doing now, I mentioned this before, is to survey the couples who were married in this period. That's going to be happening in future months. So we see, we've asked the registrar for his perspective. Do you plan to do this, or have you recently done this? But he may be over-reporting that as a result of the training. So where we'll actually see whether this really shifted what they did in practice is when we ask other people who were there at the time. So we ask the couples, ask their families, what happened on the day? Did he ask the bride? Did you know what was in it? And in fact, do you even know today what was in the form that you signed? So we'll be able to observe whether there's any significant impact on that. And then I should say that so far in the data we've collected, which is a very partial sample, we don't see a significant impact in whether or not, in the Lahore data, on whether or not, so I said before that they're less likely to cross out the delegated right of divorce section, but we don't see an increase in giving the delegated right of divorce, which is a very, very small proportion of the total anyway. It's a pretty tiny proportion. But those people who stop crossing it out, they're shifting over to taking no rather than crossing it out. So in practice, they may be telling us that they're advising to do this more often. We don't know whether they're actually advising and people aren't listening, or whether they are not really advising and just saying to us that they are because they sort of think that that's what we want to hear, or indeed that there could be something happening in other parts of the province which we haven't picked up on yet because this particular data so far has only been collected in Lahore. And one possibility that can explain this, of course, is that they are actually more open to allowing this, but the families aren't pushing for it, or indeed are pushing against it. So one of the next steps that we're exploring in collaboration with PCSW's existing program on this is to work on complementary interventions with the young women themselves. So you might imagine that a woman will be more likely to get better terms in terms of the contract if two things are happening at the same time. Number one, she asks for them, and number two, the registrar is willing to consider them. Those two things might not be sufficient conditions, but the two things together might be more powerful than just one of them alone. And so PCSW has been running a program with young women in different parts of the province, part of which emphasizes understanding the nikahnama before you get married. So they have workshops in which the facilitators hand out copies of the blank nikahnama to young women who are not married and say, this is what you're going to be asked to sign. Have a look at it. Let's talk about what's in it. What does it mean? If this box is ticked, what is that going to mean for you one day if you do decide that you aren't, that you're not happy with the way your husband is treating you, or you want to work and he doesn't want you to. So what we hope to do as a next step is to link these two pieces together and test whether the training of the registrars and the training of these future brides together make a bigger impact than either one of them alone. Another idea that's also been discussed is to engage female union counselors. So many of you probably know that there are women union counselors by rule in every union council. My understanding is that in all of the work that PCSW did across a large part of Punjab so far, and in all of the data that's been collected on the marriage registrars and the UC secretaries, there have been exactly 0 female registrars and 0 female union council secretaries. So these government agencies at the local level are not very accessible to women, especially in parts of the province where there's a lot of gender segregation and women don't feel comfortable approaching men in an official, in any capacity, but still less in official capacity. So one possibility could be to engage the female union counselors as they are, a part of their role is to serve their constituents. So making government more accessible to their female constituents could be a part of their role in the future as well. So that's something that's sort of a possibility we're keen to explore. So that's all I have today. We have, as you can see, a lot of data collection that we hope to do in the future, in particular surveying the families and doing longer term follow-up to see how long the registrars remember what they've been taught and whether it makes any kind of longer term impact, as well as looking at the marriage contracts from other parts of the province. But I'm very keen to hear feedback from obviously the rest of the panel, but also the group who's come as well, because I think there's a lot of expertise on this issue in the room, and looking forward to hearing more.
Which is the ramifications or implications for women when the nikahnama is not filled accurately. I think we are going to move on to Sohail. But just before that, I want to give a few figures which will help put this Kate's evaluation into context. The plan was to train 39,000 marriage registrars and 10,000 union council officials. We found that, first of all, the government did not know how many nikah registrars there were, but finally when the data was collected, we found that, as Kate had earlier said, out of the 39,000 marriage registrars, not one was a woman, because there is a perception that women cannot be nikah registrars. So there is that whole social norms or the mindset issue to be dealt with in this thing that we're going to talk about a little bit, I think, in Sohail's presentation. Out of the 39,000 nikah registrars and the 10,000 union council officials, the total of about 49,000, about 24,000 have been trained, and the remaining, there are plans to be trained. What did not come out very well, I guess, and that was not part of the evaluation, was the resistance of the nikah registrars, because I've personally gone into trainings also, and there was a resistance to dealing with underage marriage, because despite the fact that nikah registrars are public officials and they are licensed by the government, they felt that 16 must not be the minimum age of marriage, and the minimum age of marriage should be the onset of puberty. Similarly, there was also a complete resistance to the delegated right of divorce. And we know that because they strike out the right for divorce. So I feel that, and that was our experience, that this is a very small step in a very large scheme of things, where we start off with awareness. We take on or rather we have to take on social awareness is when you know your rights. But then even if you know your rights, you cannot access them because of the social norms. You know, the delegated right of divorce, most educated girls, women, do not take on that right, do not access that right, because it is felt that it's going to challenge their prospects for marriage, and it's going to break the marriage, the engagement for that matter. And then there is the capacity building aspect of it. So we are not, just to contextualize, or rather put this in context, we are not expecting tremendous results from this. In any case, one-time intervention is not going to bring about a change in the mindsets which have been formed from thousands of years of patriarchy, to put it simply. But there are lots of implications. The law was changed recently, and Sohail is going to talk about it. Law ensures that the minimum age of marriage is observed. There are penalties for marriage registrar. There are penalties for parents also if they officiate on underage marriage. Women are given the rights in marriage, but the law is yet very far from being implemented. So over to Sohail on implications for women. Thank you.
I go on to the slides, for example, to demonstrate that what sort of issues are there when we say that if these things are not properly filled, and then who is responsible for those? Is it the parties concerned, nikah solemnizer, who may also be the registrar, or even if they fill out, then what happens? And the third party, which is will actually focus, is the courts, how their interpretations have affected very negatively, and the tussle goes on. Okay, some of the factors, I mean, I've been doing nikah registrars training since early 90s, and in all parts of Pakistan, and sometimes it's great fun, to be very honest. Fun in the sense, I went to a village near Lahore called Maliwal, and they were reluctant, and then once they got gathered, they even forgot to go for their Jummah prayers because they were promised that there is going to be good meal. And second, there was personal issue, which often happens, and in your trainings it would have come, that license is issued in one person's name, and actual solemnizers are 20 others, And then the commission and the tussle with the union council. Well, that's not my directly subject today, but that was the vested interest. And once they were explained that how it operates, then they remained, they said, okay, ji, fair aana, zarur, right. Okay, some of the reasons very quickly. Number one, it is that the questions being asked in the nikahnama, the information, is not correctly understood, right? If you look at the nikahnama columns, there are actually, if I would divide in language sense, there are three formats. Either the question is straight away, your name. Okay, tell your name. Second is, if this happened, right? For instance, if the bride appointed a representative, and there the word vakil is, it's if. Third format is whether this was done or not. Whether any restriction on husband's right of talaq. If so, what? Right. So this straightforward question, if and whether, these are not properly replied. That's the first mistake which happens even while writing the basic facts of the parties, the ages, their fathers. For instance, I have come across hundreds of such nikahnamas, and my pile, I have a collection called Unt-Shunt nikahnamas. And that's growing, rapidly growing. That if there was a bride appointed a vakil, yes, name is written. Witnesses to such appointment, nothing written. When it came to the groom, the same question is asked, and the answer is, ji, dula bazate khud hazar, right? And then there are two witnesses written. So these, even the very basic recordings go incorrect. Now, so that's the first reason. Second is that this classification, that they mix up things. For instance, very common thing is bridal gifts and dower mix up, and in the write-up, and in their understanding. Third is incorporation of local practices and trying to squeeze those in within the ambit of law. There can be a different local understandings of certain things, right? But how does law recognize that? I will come to that example, because certain conditions which are settled, which deal with the future happenings, and specifically incorporated in column 17, and often are either void straight away, or they imply something different but what they meant. Fourth is fraud. Fraud between the two parties. They say, ji, de rahe hain. I'm sorry, I will be using the line. Acha, how nikah, whoever is solemnizer, and I come across, I spend most of my time in my village and have to be present in every problematic marriage. Right? Problematic, I mean, where the case will come back to me, so after a few days or in the neighboring area. The people who have to write, and I often in my village marriages now I write on the nikah register myself, so that I clearly know what was settled there and how to, what was incorporated and in the correct language. Right? So there is a fraud that if something is promised. For instance, I came across a case which had went up till High Court, and it was, what was the issue? That the bride thought, the bride side actually, bride directly is rarely a party, that she is being given this house in dower. And actually there was written कि उसको शादी की शुदा ज़िंदगी के दौरान रहने की इजाज़त होगी. So that's a big difference, right? Right? Okay. So the last but very pertinent point, I mean my major classifications, is that our nikahnama has certain columns, conditions, which can be settled straight away on the form, and there is no harm in doing additional things. Law permits that. But there are not direct statutory provisions to back that. And our CPC judges, I call, Civil Procedure Code judges, too technical minded and totally ignorant of the mother law, right, which is the Muslim personal law, right, which governs that. And they get entangled with the Transfer of Property Act, with the Contract Act provisions, and deny relief. And partly also their interpretation of an issue. Right? So I will come to that later. I start with very simple examples. Now these and all the slides which I am going to show are the cases which went up to High Court. Not even the family court, or if there was in certain instances appeal to the district level. She has been given this right as per Sharia, means nothing. Second, she has been delegated this as per fiqh is so and so. I did not write the name of fiqh. I mean, somebody may not be offended. I deleted that, right? Third one is, that's funniest. Yes, she has been given this right. However, she will exercise with the, what you say, consultation of elders of her family. Now, who is going to determine this? Yes, permission, ijazat se, right, permission. No, it is not elders' nikah. They may be consultant, they are not party, they were not living. This third case actually was decided by Fakhrun Nisa Khokar, and Alia would know how tough judge she was. Because the proceedings, once she served, it's a Lahore case, and what you say, the secretary and in those days it was the Nazim, chairman was called Nazim. Both pretended they are very educated. They even seek legal advice, and their legal advisor also appeared, right? Because the grooms objected that it has not been correctly exercised. She did not consult the elders, right? Permission was not there. Well, Fakhrunisa gave a good and then there was sectoral question also. She said, once a notice has been served, she was adult, we will assume that everything was done. But what was the result? Something which should have been over after 90 days from the receipt of notice by the chairman, it got prolonged for over beyond a year. Next, please. Acha. No, this one is what I said, incorporation of local practice, local understanding. शोहर बीवी की इजाज़त के बगैर दूसरी शादी नहीं कर सकता. But you keep on writing permission authorities, arbitration council concerned, right? So it does not make a difference. Okay, will it be that for arbitration council may consider this factor, that in the agreement of nikah, he said that. So, but it is subject to interpretation, right? Second is bila jawaz nahi. यार तलाक दा कानून ने किथे पूछा कि जी वजह दो, right? Again, very ambiguous thing, right? But however, there can be some judges, and these days there are some that were saying, yeah, this should be unraveled, what it may mean. Third one, बगैर किसी कसूर किसी जुर्म के ना हक तलाक, कभी हकी तलाक भी हुई है, ना हक तलाक, ये this is the pet language of the nikah registrar. ना हक तलाक की सूरत में 2 लाख रुपया अदा करने का पाबंद होगा.
Did it stand in court?
Yeah, this was decided by Maulvi Anwarul Haq in what you say, a case from Mayawali. Yes, I come to later because this is point of dispute. This is right. Now, actually, the groom was idiot. The way he did made a mess of his life. No, I said that the court's interpretation question, and I hold point 90, the last one, to that when I come to that. But, I mean, don't keep suspense for long. This was upheld. What you say, compensation was granted. But the way Anwarullah granted, he interpreted it as personal property of wife and belonging, but somewhat compensatory aspect also. And he said because the husband in notice of talaq alleged his wife to be of bure kirdar ki hamil hai. There the judge, right, Anwarul Haq got annoyed with that. He said, well, did the law ask you to give reason? Or now if you gave the reason, then you are to prove that socially or in local circumstances. So that's how the case got, by the fault of the language of the notice. And then what in the family court, the way proceedings had happened, and in the cross-examination, certain admissions of the husband actually landed him in trouble. But this judgment remained a disputed judgment and was overturned frequently, and our worthy current Chief Justice, he is bent upon to crush Family Courts Act. Alia is nodding because she might have suffered when he was in Lahore. His interpretation is, कौन सा जी? ये मैं इसका citation आपको दे देता हूँ, please do remind me, right? अच्छा, ये 2004 का decision है, but I will, और SLR में report हुआ है, Sharia law report में, ठीक? अच्छा, अब now what happened? Number of other decisions in the high courts also differed with that, and the primary difference was on 2 points. That is it an actionable claim under Transfer of Property Act? Does it fall in the ambit of what is written as item number 9 in the Family Courts Act, personal belongings, and it remained, few judgments went this way, some went that way. Sakam Nisar in Dr. Sami, that's 2011, in PLD reported Supreme Court, I will, if you need citation, will give, that he, what you say, put the final stamp, that the family court does not have jurisdiction. It should be the other civil court, right? Which is absolute incorrect interpretation. Preamble of the Family Courts Act says marriage and the matters connected with, right? Luckily, Punjab amended Family Courts Act. Now the item 10 in the Family Court Schedule says any matter arising out of nikahnama, right? So this stands resolved under that. And then what you say, the Supreme Court recent judgment, not that recent, but Ijaz Afzal judgment, PLD 2016, Supreme Court page 613, Muhammad Ghazanfar and others. In that it was division bench, Mushir Alam and Dost Muhammad resolved this controversy also, right? That it is specifically in view of the Punjab amendment, and also he, thanks to him, he resolved this controversy that this will apply retrospectively because it's a procedural law, so it does not mean that what you say, only the issues which come, matters which happen after, and said family court has the jurisdiction, right? And specifically the aid was by the amendment. जी आगे जी अच्छा now again very simple mahar की रकम मुबलग 5,000 रुपये अच्छा second one सालम महर मुबलग 5,000 रुपये बवक्त निकाह दुल्हन की तरफ से माफ किया गया है, right? This is something where you can catch nikah registrar, right? Because as I have been critical of our judgments, but there are as also, you know, our family laws 90% is based on case precedents, right? Some very, very progressive judgments. Relinquishment of dower subsequent to marriage, right? There can be no prenuptial agreement because it's mandatory requisite. So forget it that there can be no dower, or a woman can say even if she agrees I will marry without dower. Now, there is a difference between Hanafi school and Shia school over there, that what can be or can't be, and in a couple of judgments, Fakhrun Nisa Khokar discussed this point at length. However, it is ought to be there, right? So it's a mandatory requisite. And my request to those who wear black coat, black tie, I don't, because I don't belong to them, but they are friends and often we fight as well. Please, when you define dower, our problem is the lack of consistency. We say consideration of marriage. It is not. That's a very, very bad interpretation. That is in relation to if you equate the contract of marriage with contract of sale. And consideration is what I don't want to go into that, right? It is a requisite. People call it even gift. It's not a gift. Gift is not mandatory. Gift is ought to be voluntarily, but it is mandatory. So not consideration of marriage, but it's a mandatory requisite of marriage, right? So this has been debate of over 100 years, and in many law schools over here, I have seen, been part of those, that they teach it, it's equal to contract of sale and blah, 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 and that's why, but the moment they say consideration of marriage, then they also say wife to fulfill certain obligations and to be obedient, to be faithful, blah, 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 right? So, okay, next. So this relinquishment, if the matter goes to court, our courts have been very strict about the relinquishment. And even I give you a very old example, it was 1956 case, the husband said, I will go into polygamous marriage, first wife said, please don't do, husband said, acha bin fir pyar karni hai, to fir paise nikah khatam karna, right? Subsequently, she filed for suit for dower, it was upheld, High Court even granted interest. Right. They said, do you think that somebody being tested, that the test of love against a relinquishment of dower, that's not acceptable. That is, even if she did, and she had done it in writing, they said it's void. We don't acknowledge that. Right? Go on next. Okay. अच्छा जी ये है. अच्छा अब ये जरा जी इसका क्या करेंगे? कुल 30 लाख रुपए 15 लाख में मकान नंबर फलाना डिलीटेड, यार पार्टीज का ज़्यादा ही ना पता चल जाए कि किसका घर था। अच्छा आया मार का कुछ हिस्सा शादी का मौका दिया तो किस कदर इंदुल तलब, राइट। अब यार ये लिखना है तो वो डिफर के साथ आगे लिख। अच्छा आया महर या इसके बस कोई मौजूदा मकान दुल्हा के वालिद की मलकियत है, दुल्हा की वालदा के दासत। यार ये जिधर भी जाएगा एक प्रॉब्लम ही पैदा करेगा ना ये निकाहनामा। अच्छा ओवर हियर व्हाट कुड बी डन, सो बेसिक गलतियां हो गई। अगर वो प्रॉपर्टी, द पॉइंट विच कैन बी लीगल अटेंशन, इफ द प्रॉपर्टी डिड नॉट बिलोंग टू ग्रूम, even that could be accepted and the father would have been made guarantor and signed as guarantor. That should have been upheld. But mother is not the owner. Why should she be? And it's so these sort of problematic feelings actually prolong litigation. Then somebody will advise, don't go to family court. यार suit of specific performance होते ना civil court से करते हैं, ठीक है। वो अच्छा इधर से एक इधर कर देंगे, उसकी अपील हो जाएगी, वो जो खिचड़ी पकती है वो वकीलों को ज़्यादा मेरे से पता है। आगे जी, ओके दिस वन फ्रॉम द केसेस आई हैड टू गो। 10 तोले जेवर दुल्हन की मलकियत होगी, यार किसने दिया, ये कौन सा था। नाचाकी या बीवी को छोड़ने की सूरत में खामन बीवी को 2000 रुपये माहाना खर्चा देगा, 50,000 रुपये अदा करने का पाबंद होगा। Okay, now this point, first the technical side. There has been dispute in our jurisprudence that can you make a settle a condition about future separation and its implication. It's a point of contest, right? If we go about 120 years back, Privy Council decisions even have upheld that, right? But it's some say it's contrary to the, what you say, public policy. Some would say opposed to the law of marriage or the law. So it's a point of contention. There have been few judgments either way. The question is, but this particular one, High Court did not accept, and I utterly differ the grounds on which, what you say, certain things they did. Why? They didn't, High Court did not give arguments on this issue that could it be settled as a condition. High Court, you know what did they do? It was written in column 20. He said, oh, in column 20 you write down, like, you are supposed to mention the documents, if any, prepared in relation to payment of dower and maintenance. So on technically it went away, right? Not on merit. Ji, next. Acha. लो जी, अगर बीवी खुला ले तो खामद को 2.5 लाख रुपए अदा करेगी, अगर खामद तलाक दे तो बीवी को 2.5 लाख अदा करने का पाबंद होगा। This went up till Supreme Court, right? Marriage was in 1970. Khula happened in 2004. Okay, it's a very short judgment. What you say, it was full bench, but what was our Chief Justice Sheikh Riaz judgment. He asked one question to the council, can you point out any law where a legal right given or under the Sharia or the law can be curtailed? Perhaps he was advocate on record, he would not have read the file even. Oh, he did not say, he said he does not speak. Dismiss karo, leave to appeal, refuse karo. But it was clearly that a woman, if khula is to be granted by court, so any such condition would be void, right? So it will not be, husband cannot claim, because she got the khula and husband had filed ke ji wo 2.5 lakh nahi dete family judge ne. Aage. Acha. Oh, very contentious, right? वक्त रुखती सोने के जेवरात वजन 10 तोले और एक मकान वाक़या मोहल्ला फलाना भावलपुर मालियत 2 लाख रुपए दिया जाएगा। खामन दूसरी शादी करेगा, बीवी को तलाक देगा बस या देगा बसूरत दीगर, वो बीवी को महर के अलावा 2 लाख रुपए अदा करने का पाबंद होगा। Now in this case there were multiple claims by the wife. It was what you say, marriage where there was nikah for 3 years, no rukhsati happened. Her maintenance claim was upheld till husband pronounced talaq and all the proceedings. But this thing that it was what you say promissory thing, but it is written in the dower column. Court did not grant and did not give any justification. And this is, I'm talking of High Court decision, right? So about this one, Khawan ya biwi ko basurat digar wo, this over here what you say, lengthy discussion and said it's not opposed to public policy if you put a restriction on husband right of talaq. Earlier there have been judgments where courts say there can be no restriction, right? But there he clearly spelled out rest of the issues settled, some other principal points settled, but the actual claim not given. I stop, Fawzia signaled me, and rest is up to the questions.
Very interesting. I'm actually just going to add a little bit to this because these are problems that arise from incorrect filling of the... हाँ जी बताएं.
यार ये slide दिखाना. Last point. जो निकाह registrars के लिए mandatory है. Where you stop next. Now, one last point, how our courts read nikahnama filling. In many instances, they try to make sense of it. And they don't go very strict as the judge in one went. They say, यार इसकी कोई समझ सकता है इस निकाहनामा की? 7 तोले सोना महर में तय हुआ, कितना मुअज्जल गैर मुअज्जल पता नहीं, कीमत सोना 24,500 रुपया आया, पूरा महर नीचे लिख दिया मुअज्जल. The woman went for khulai. This is 92 वजूद्दीन की जजमेंट है कराची से. So उसने ये कहा कि वो लड़के ने कहा जी लड़की की माँ को दिया था. उन्हें कहा निकाह ओदे नाल होया सी कि कुड़ी नाल होया सी, ठीक है. And then long paragraph के औरतों की ill treatment. So this could have been dismissed. It does not make sense. But they said we will try to read it. However, there are now cases where the courts sometimes become in अगली slide पे बेटा जाना. Okay, done. Okay, now, a very critical case. 3-member Supreme Court bench. PLD 2011, Supreme Court, page 22, Dr. Asma Ali versus Masood Sajjad. Often being now quoted. Why? शादी बड़ी महंगी थी. Prom dower सुन के jealous होना है या हमने envy करना है. 60 tolas of gold. 2 canals house. Amount is price settled 7 lakh. 100 canal agricultural land. No specification and location given. Okay. Though the groom's father even executed an iqrarnama that he was guarantor. Case went up till Supreme Court. Bench was Tariq Parvez wrote judgment. Nasrul Mulk dissented. Shakrullah Jan agreed with the majority verdict. 2-1 pe aayi thi. And personally speaking, I was appalled that Nasir Saab, brilliant judge, but his knowledge of Muslim law was appalling in this judgment. Right? Finally, the key question was that unless you specify, column 16 asks, how will we know, who will identify? The others went by, it is dower, it is the responsibility of the giver to do that, and we will not defeat the right of dower on technicality. Right? So that Tariq Parvez wrote a very lengthy judgment, and I'm glad that I've seen it's following in the High Court's other judgments. One Pindi bench judgment was such that there was a house, and a High Court ordered that the family court that revenue authorities be ordered to find a house equivalent of this price and tell where that location can be, and husband will pay the market price. So this Asma judgment was followed there.
Very interesting, Suhail. As always. One was, एक तो knowledge of the registrars, because of which we have blunders like this. Dusra, the question of intention. A lot of times we've seen that this is done deliberately, ताकि आगे जाके मसला हो. Many a times, at the time of registration of the nikahnama, उसकी terms change कर दी गई होती हैं because the nikah registrar often gets a signature without filling in the details and then fills in subsequently, right? That is our other problem. Then, of course, the third problem that Suhail has talked about is interpretation by courts. Who is going to decide and what is the mindset? We've come across other policy and administrative issues related to the nikahnama and the registration of the nikahnama. And those deal with the rules that govern the registration of the nikahnama and the marriage registrars, the bylaws and administrative actions. So in terms of those policy level or rule level issues, we found out, ek to ke there is no qualification set for the nikah registrar at the moment. A nikah registrar could be illiterate for that matter. They are supposed to explain everything to the bride and the groom, but they could be illiterate. We've come across instances when the nikah registrar is actually blind, deaf and dumb. But वो खैर करता कोई और है, fill कोई और करता है. So that is one of our problems, that there is no qualification for the nikah registrar. What it needs, therefore, is that the government should make rules regarding registration of licensing of the nikah registrars. And usme there needs to be minimum qualifications, and we've proposed, having gone through this training of so far 24,000 nikah registrars and union council officials, we've come across some of the measures which were very timely, or some of observations which were very timely, because abhi government 100-day reform agenda pe kaam kar rahi hai. So we've taken that opportunity to propose legislative and policy measures which will plug some of these gaps that are available. So we've proposed ki kam se kam minimum metric should be the qualification. And there should be some age limit, because I'm sure Kate also observed from the evaluation, some registrars are like 80 years old, wo ja bhi nahi sakte, they can't see, and we expect them to diligently fill the nikahnama in an informed manner. The other problem is that there is no real standardized format of the nikahnama. It varies from, of course, province to province, but within the province, from press to press, district to district, And that, I think, Hannah and Kate, you also observed that in Punjab also, that isn't done. Pehle we had, I think nikahnama was printed by the printing press, right? Not any longer. Anybody can print a nikahnama. So we have different provisions, in fact. Some more detailed, some are slightly abridged versions. But definitely there is no standardization. And that is another policy level suggestion that has gone from the Commission to the Punjab government as well as the federal government, because both governments are working currently at legislative reform on which the Commission has led. And some of you have participated in some of those consultations also. Here, we've given punishments for incorrect filling without the consent of the bride and the groom, mandatory registration of the nikahnama. But there is no enforcement of those punishments. There is no monitoring to begin with, and then there is no enforcement of those punishments. And there is such a level of, I'd say, brazenness about it. Okay, the training that I mentioned earlier, which I went to, I've been to many, but one particularly in Lahore that I went to, the nikah registrar said, you can do nothing, and we don't care if you are forcing us to do, not to register underage, rather to register underage marriages, which we don't believe in, because we believe that marriages should be performed at the time of puberty, you can do nothing about it because this is Shariat. So when we tried to talk to them about the fact that they were public officials and they were bound by the law, they simply got up. It was a Friday. This time, Sohail, they got up and they said, Jumme ki namaz ka waqt ho gaya, hum ja rahe hain. So this is the selective use of religion when it suits them, and they just left, So first of all, there is no monitoring, then there is no enforcement of punishments, and even when you want to enforce punishments, there are challenges which sometimes we cannot take. And this is the time when Khadim Hussain Rizvi had given the dharna in Islamabad, and they knew that they could take us on that one. So these are some of your higher level challenges that I have to say. The other thing, the problem is that there is no method of age verification, no proof of age that can be attached, because in any case, 18 is not the minimum age of marriage for girls. So CNIC production, while we try to ask for CNIC for verification of age, it doesn't happen because 16 is the age. So another policy recommendation that has gone now is that Bay form should be attached with the nikahnama mandatorily, so that an age verification can happen. Then some problems that the nikah registrars face themselves. One of the bigger problems that we've seen is that their fee is like between 2 rupees and 20 rupees, A person who's being paid 2 rupees to 20 rupees, what do you expect from them? What level of accountability can you hold them to? It's just like the civil servant who's paid, or the policeman who's paid so little, who used to especially be paid so little, and we expect a lot from them. And that is subject to bylaws. Every union council can make its own bylaws and can set the registration fee. So that is another policy level issue which I was supposed to talk about, that a decent amount for the marriage registrar's fee, it should be that he charges from the people, that should be established. And also another fee is that of the license. That also varies. Marriage registrar's licensing fee varies from one union council to the other. So that standardization is also required. Finally, at the moment, the nikah registrar, and Suhaila touched upon it, the nikahnama rather, has no provision for mandatory attachment of the documents which are required to go along with the columns of the nikahnama. If that is done, like in his instance, the property documents to be attached where it is promised, or any other amount or any other document which is required, if they are either attached or the guarantor signs for those, a lot of our problems would, I think, be reduced in courts. So these were some of the policy level implications. I think we've had a good discussion on the various challenges, where those challenges lie, and what are some of the solutions. And I think with that, we can open the floor to questions. We have, I'd say, about 15 minutes for questions and comments. जी.
अच्छा देखें जी, दो चीज़ें हैं कि ये फौजिया ये जो क्वालिफ़िकेशन की बात है, हमारे वाला ये कानून बांग्लादेश में गया, तो in 74 when they enacted another law, registration of marriages and divorces, section 5 MFLO वाला उधर नहीं है थोड़ा, but they what you say spelled out the qualification of registrar, and they put a test कि जी number 1 school, secondary school certificate, second knowledge of these laws, and they will go through test and this monitoring issue which you have highlighted, performance based. And this because our license theoretically as per rules is permanent till it's revoked or cancelled, yes. Right? So they said that no, it will be what you say, there is a board which does that, at least in law, right? Second issue, this fee of nikah registrar, jhoot bolte hain. There is a duplication here. Family rules under MFLO also spell out fee, and they will refer you to that as per quantum of dower ji 2 रुपए. No. और मेरे गांव में 5,000 है तो वो कैसे कहता है? मुझे को करा के तो दिखाए निकाह, बिल्कुल झूठ बोलते हैं. Then the union council annually duplication इसकी ये है कि union council के जो mandate में आते हैं ना कि जो टैक्स है, तो वहाँ पे आप उनका notification जुलाई में पढ़िएगा, लिखा होगा निकाह अंदराज फीस इतनी, ठीक है, राइट. तो अब झगड़ा पड़ता है कि जो MFLO के तहत रूल्स हैं, डिवीजन ऑफ फीस 80% रजिस्ट्रार, 20% UC, देयर द सेक्रेटरीज डू फ्रॉड, राइट. सो एंड द निकाह रजिस्ट्रार्स टू रिटेन देयर लाइसेंसेस, दे हैव टू what you say agree with whatever they say. So it should be recommendation be that the fee what you say जो family rules में है, that should be deleted, that's absolute now, and what you say one fixed fee by the union council to be fixed, and then within that the division of 80-20 can continue, right. So this excuse no, that minimum बड़ा गरीब बंदा भी हो तो आजकल वो 3-4 हज़ार झाड़ लेते हैं मौलवी, right. अब दूसरा है कि निकाह खां और रजिस्ट्रार के दरमियान क्या डिवीजन है, ये उनका आपस का सौदा है, ठीक है.
Okay, so I think you should refer to the questions. पीछे से we'll start at the back.
Hi. So I'm following one case recently where there is like the bride and groom they ended up filing for divorce, but they recently discovered this that in order for the divorce to get completed, they have to like wait for about 3.5 months. Like there is a consultation process that they say कि आप मुफाहमत कर लें, you get back to it. So you think it's necessary for a couple to wait for 3 months and then it's followed by a 4-month iddat and all that? Like just
सवाल भी वाज़ेह करें कि ये जब डिवोर्स किसने, बंदे ने तलाक दी या औरत ने? वुमेन फाइल्ड थ्रू द कोर्ट. नहीं, वुमेन कैन नॉट फाइल थ्रू द यूनियन काउंसिल अनलेस शी हैज डेलीगेटेड. Okay, hold on, listen. If she is delegated has right, so it's the same for the man. When it's delegated, talaq procedure is the same. That's a reconciliation proceeding. Baba, it took ages women rights activists to do away with triple talaq there and then ending, right? And the family, our MFLO, which was framed, the Family Law Commission's main recommendation was that this, because the statuses of marriages don't remain clear, men overnight divorce them. So under the current law, every form of divorce, whether it's talaq, khul or any other thing, is revocable. It has to go through, if it's on women's application, through the court. It has to go through again the arbitration process, right? And I do not find any sense there and then question. If you go to other countries, the laws which are slightly different. First, divorce degree nasi is issued. And there the time difference usually 6 months before it becomes degree absolute. Same is in Pakistan for the Christian divorces, that it's not instantly issued. And this is nothing new, it is since 61.
It doesn't have a standard form and any press can print them. I'm wondering what exactly is the variation between forms there, because the exact text of the nikahnama is specified under the rules under the Muslim Family Laws Ordinance. So what sort of variance do you see there?
Frankly, पहली बात तो ये कि मुख्तलिफ presses right at the moment different printing presses are at liberty to print them, right? From what I remember having seen in one of the nikahnamas, a provision was absent, you know. It was sort of an abridged version of the nikahnama. Similarly, in Punjab, you have the provision for CNIC on it, whereas it doesn't have to be there, but there is, it works in our favor, but there is no standardization on that one. So these are some of the things, and of course, our trainers observed many others also, which I can get back to you on.
Column 17 in several special conditions is absent, right? Our nikahnama primarily used to be printed at Bawalpur printing press. Now it is at Urdu Bazaar, right? And in the market, the union councils purchase registers from the market, from that, and then they stamp of the union council. There are other distinctions also. If you find the properly from the government printing press, it will say on the 4 originals, Parth 1, 2, 3, 4, right? It will, the others don't spell out that. And as Fauzia has pointed out, the CNIC numbers in what you say, where the name of the bride and the groom in columns is written, their ages, there also number is. When the signing page and witnesses, their CNIC's number columns are there as well. And then in the language of muwajjal, I have come across nikahnamas where it is written, mahar ka kitna hissa muwajjal hai aur kitna muwajjal hai. Again muwajjal, right? So what you say, these are what you say proofreading issues, but this, as Fazia said, and then column 16 is sometimes not complete. That these.
अच्छा सो बेसिकली मैं कोई लॉयर वगैरह नहीं हूँ या मैं कोई टेक्निकल बंदी नहीं हूँ सो आई जस्ट वांटेड टू नो कि क्या चल रहा है और क्या अपडेट्स हैं सो स्टार्ट में जो रिसर्च का काम हुआ था आई कुड गेट दैट बट व्हेन इट केम टू दिस पार्ट आई वाज सो ओवरवेल्म्ड कि आधी से ज़्यादा चीज़ें मेरी ऊपर से गुजर गई हैं सो हाउ वुड यू सजेस्ट या आपका ये सारा प्रोसेस करने के बाद व्हाट वुड यू थिंक कि what should a woman herself have to go to a platform जहाँ पे उसको इन चीज़ों का अंदाज़ा हो so she can go or discuss all these things with this registrar या जो भी है with her family या जो भी चीज़ें obviously technicality इतनी ज़्यादा है इन चीज़ों में so if you can
address this
something.
question. You're very right that there was an assumption that everybody here knows about these issues, and इसलिए पहले Kate ने सवाल भी किया था कि how many of you are researchers, how many of you are lawyers, and we got a sense because this is a research forum generally. But I agree with you. We probably should have unpacked it a little more. There are other forums for understanding the rights in marriage, the nikahnama, how it is constructed, how it should be filled, etc. We do that as the commission. We do it in a couple of ways. Ek to we go into colleges, universities and other places and explain in detail what to completely lay persons, your students, जिन्होंने कभी निकाहनामा का ना सोचा भी नहीं होता, let alone देखा हो, उनको clause by clause उनको explain करते हैं कि what it means and how they should fill it if and when they get married. दूसरा, there is a helpline that, again, there's a government helpline, the number is 1043. If you call it, they'll explain the rights in marriage to you, they'll explain the columns to you, and they'll also take complaints whereby anyone's right has been denied because of the marriage registrar or for whoever they're asking about. Then there are websites also जिसके ऊपर ये this information is given in detail. But just to give you a quick solution, if you go on to the Commission's website, the Punjab Commission on the Status of Women, you'll get a lot of this information, and call 1043. They'll also give you information. Okay? Anyone wants to add to this?
That it's basically the nikahnama is not first of all not standardized, and also its language is not that much lenient and formal for the to understand, even for the families and for the witnesses of the lawyer and जो वकील होते हैं ब्राइड के. So आई डोंट थिंक हमारा सोशल सेटअप जो है वहाँ पे ऐसा होता है कि ब्राइड को हर सेल्फ ऑब्जर्व करने का या उसको फिलअप करने का या उसको पढ़ने, इवन उसके नॉलेज में वो लाई जाती है, जो बेसिकली दिस इज़ द बेसिक रिस्पॉन्सिबिलिटी ऑफ दी विटनेसेस, जो कि उसके जाते हैं और उससे उसकी कंसेंट मालूम करते हैं और उससे साइन करवाते हैं, गेट हिज हर सिग्नेचर्स. उनको जो है वो उसको सारा, बट मेरा ने ख्याल कि वो खुद उनको उस लैंग्वेज को अंडरस्टैंड करने का कुछ पता होता है कि वो क्या लिखा हुआ है और वो क्या, और वो इतनी कॉम्प्लिकेटेड है. नहीं मुझे मैं जब जितने भी मैंने कॉलम्स जो है वो आपने रीड किए हैं जी, उनकी अंडरस्टैंडिंग इतनी लो है कि बीइंग मतलब मुझे नहीं समझ आई किसी को.
अच्छा, मैं आपको एक छोटी सी है, इसको इतना भी मुश्किल ना बनाएं, इतना हवा नहीं है. कॉलम 16 जो है वाकई थोड़ा सा मुश्किल है, और अगर उसकी 16 की एप्लीकेशन ज़रूरी नहीं, मैं हमने रिकमेंडेशंस में कई दफ़ा ये कहा है कि कॉलम 16 भी बाइफरकेटेड इनटू 3 पार्ट्स, राइट. हाउएवर इट्स नॉट, आई डू नॉट एग्री, इट्स नॉट डिफ़िकल्ट. सेकेंडली इंटरेस्ट की बात होती है, और दूसरा प्लीज़ ये ना कि ये स्टैंडर्डाइज नहीं, इट इज़ स्टैंडर्डाइज. व्हाट वी आर सेइंग इज़ दैट the way it is being printed, there are administrative problems happening.
It's not a control document.
नहीं क्या,
it's not a control document.
देखें, कंट्रोल या गैर कंट्रोल एक अलग फ़र्क है. It's under a law, एक सेकंड सुन लेना. It's under a law, given a specified thing, right? Now it's part of administrative legislation, and some at times what you say, they issue notifications that you will, because the ages are to be recorded, so you can add. That government can do. There is not a problem. We should not go much into that. We should be just demanding that ensure nikaahnamas as envisaged under the law be printed in uniform pattern and any mistakes be checked. That's it. So use of word, it's not standardized, is not correct. Second, there is a difference in nikahnama which is enforced in the province of Punjab and the other 3 provinces. We have some extra columns asking for certain statuses. Part 2, it's not difficult. मेरी शादी से ज़्यादा कहते हैं जी औरतों का, ये उस वक्त तो नहीं करना था. बेबा जब शादियाँ होती हैं, ससुराल वालों को लड़की की क्या पसंद है, कपड़ों के रंग, सारी बातें मैं पहुँचता है ना, उधर का भी पता होता है. इट्स मैटर ऑफ इंटरेस्ट. ठीक है, सिंपली कोई जी ये सारी बातें सामने बाकी टेस्ट करते हैं ना जी, लड़की वहाँ पे रहेगी या हनीमून तक सारी तफसीलें तय होती हैं ना, तो निकाह की शराइत में भी उतना ही बंदा जोर मारे ना. आई एग्री विद द डिफ़िकल्टीज़ एंड चैलेंजेस. आई एग्री कि मुश्किलात होती हैं डेलीगेटेड राइट पे, या कुछ हमारे मजहबी मामलात ऐसे हैं कि कुछ हमारी फ़िक्र जो हैं, सोशल भी है, लेकिन बाकी जब आप कंपैरिजन में रहें कि बाकी चीज़ों में सोशल कितने ऑब्स्ट्रक्शंस ओवरकम हुई हैं. अभी मैं फौजिया को कह रहा था, इसने कहा ना ट्रेनिंग का, मैंने कहा यार ब्यूटी पार्लर्स पे भी पोस्टर्स लगवा. दैट्स अ प्लेस वेयर व्हाट यू से विमेन आर टू गो, और वहाँ पे सुन भी लेंगी, और जो वो मेकअप करने वाले उसको कहो कि यार सारी गल्लां पढ़ा के पूरा करना है जी.
पता नहीं वो इसमें निकाह, हमारे निकाह नामाज में उसको इनकॉर्पोरेट करना चाहिए या किसी और जगह कि, चूँकि मैं फैमिली लॉ में डील करती हूँ तो हमारे पास बहुत इशू आता है कि 25 साल की शादी, 30 साल की शादी के बाद हस्बैंड ने तलाक दे दी, जो प्रॉपर्टी, जो बैंक बैलेंस वो हस्बैंड का. तो कोई एक इसमें कोई कॉलम ऐड करा दें या कहीं ऐसा हम कोई ऐसी
सवाल है
ड्यूरिंग द
मैरिटल
सब्सिस्टेंस ऑफ
प्रॉपर्टी
मैरिज जो फाइनेंशियल बेनिफिट्स या गेन्स जो कपल के होते हैं वो अगर इक्वली नहीं आप कर सकते कि यहाँ पे औरत इक्वली अगर वर्क हाँ उतना नहीं करे तो कोई परसेंटेज कुछ ऐसा आ जाए कि औरत को ड्यूरिंग द सब्सिस्टेंस ऑफ मैरिज।
उसका यह है कि कई दफ़ा रिकमेंडेशंस हुई कि देयर शुड बी रिकॉर्डिंग डिक्लेरेशन ऑफ द एसेट्स, ठीक है, निकाह में कि खामन के पास है क्या, और जब वो डिसोल्यूशन हो उसकी फॉर्म ऑफ डिसोल्यूशन को देखते हुए कि औरत की जो कंट्रीब्यूशंस एंड डिफरेंट वेज, नॉट नेसेसरली डायरेक्टली फाइनेंशियली, इन अदर वेज एज वेल, पार्टली वो एड्रेस हो जाता है। अब पार्टली पर्सनल प्रॉपर्टी एंड बिलोंगिंग्स ऑफ जो वाइफ वाला आ गया ना फैमिली कोर्ट्स एक्ट की जुरिस्डिक्शन में, नहीं सर, जहाँ पे जिसने फैसला दिए हैं ना कुछ, ये तो आप जैसे दोस्तों का काम है ना कितना पुश करते हैं। शुरू में 21 से जब आया ये कौन ही प्रॉपर्टी स्टे करते थे, हमने बड़े स्टे लिए हैं, ठीक है, कि जी ये डिस्पोजल के लिए ज़रूरी है, इसमें बीवी की कंट्रीब्यूशन है, इस बेस पे कि बीवी की कंट्रीब्यूशन है, इस प्रॉपर्टी की सेल स्टे कर दें। तो लेकिन निकाह में भी ये एसेट्स का और जो डिवीजन ऑफ एसेट्स है ये कानून में आना चाहिए। जी आई एग्री इस ये मेन लॉ में आना चाहिए।
इस पे मैरिटल प्रॉपर्टी का कॉन्सेप्ट है या मुताल तलाक भी एक होता है जो कॉन्सेप्ट है जो पूरी दुनिया में है, मलेशिया, इंडोनेशिया, बहुत जगहों पे वो अभी उस पर अभी रिसर्च हो रही है, वो विल प्रेजेंट दैट पेपर ऑल्सो। ये हमने जो 100 डे रिफॉर्म एजेंडा उसमें भी प्रपोज किया था एंड यू आई थिंक but it was not very well received, so I feel there's a lot of advocacy that needs to go into it. But I want to move on to Huria, उसने बहुत पहले सवाल किया था उससे करने की कोशिश की थी।
सॉरी, थैंक यू। आपने जो स्लाइड में डावर की एग्जांपल्स दी, तो इनकरेक्ट फिलिंग के अंदर how are we looking at the role of, let's say, the nikahnama or the registrar, right? Like he's a public servant, is he under some kind of an obligation? And secondly, like punitive measures अगर हैं तो उनको enforce करना या उसको proceedings का later on हिस्सा बनाना, like how does one go about doing that?
Before you answer, let's just pose that across the board, the inadequate filling throughout the nikahnama. So nikah registrar का क्या role है when you're inadequately filling out either section 17, column 17, 16, 18, dower है, delegated right of divorce है, crossing it out. So we know that we've seen the legal consequences when it comes to both parties involved, but we haven't yet touched upon the consequences of where the nikah registrar comes in, and if at all, if there are, and if they're enforced. So yeah.
पर यार तुसी तो पूरी किताब दा सवाल पूछ लिया। बात सिंपल है, देखो जी, निकाह पार्टीज़ के दौरान है, कानून में क्या लिखा है कि जी ही अभी जो अब सेक्शन 2A है सेक्शन 5 का पंजाब का, वो कहता है ना कि द मैरिज सोलेमनाइजर शेल फिल विद स्पेसिफिक आंसर्स फ्राम ब्राइड। अच्छा ये एंड नहीं है, ये पता नहीं उनकी गलती है, ब्राइड आर ग्रूम है। आई क्रॉस चेक गजट नोटिफिकेशन सेवरल टाइम्स, इट्स ब्राइड आर ग्रूम, राइट। अच्छा वो कहेगा जी इन्होंने इस तरह से बताया, ठीक है, ही वॉज नॉट वट यू से एडजुडिकेटर, उसकी जिम्मेदारी नहीं है। आपने लिखवाया, आपने उसकी या क्वालिफिकेशन में या उसके स्पेल आउट करें कि जी वो जो एक्यूरेसी है इन टर्म्स या जो कंडीशन अप्लाई होती है या नहीं होती है, तो वो फिर तो आप उस पर कोई लाइबिलिटी ले आए, नहीं है। कुछ सूरतों की है, फॉर इंस्टेंस अंडर एज मैरिज करा दे तो सीधा जाएगा, अगर रजिस्टर कर दे अंडर एज, वो चूँकि उसकी लाइसेंस की कंडीशन में क्या लिखा हुआ है कि के लाइसेंस कब रिवोक या कैंसिल होगा, ऑन वायलेशन ऑफ एनी ऑफ द प्रोविजंस ऑफ MFLO और द रूल्स फ्रेम्ड अंडर इट। तो वो तो दैट इज़ मैंडेटरी दैट ही इज़ ऑट टू नो के जी एजीज क्या हैं, वहाँ पे तो हो सकता है। और समथिंग विच इज़ ब्लेटेंटली इलीगल, ब्लेटेंटली, फॉर इंस्टेंस वटा सटा कि जी सटे में लिख दिया जी फलानी बच्ची नहीं तो इतने पैसे, यू कैन होल्ड हिम देयर सर्टन प्लेस, ठीक है। बट डायरेक्टली, एंड लेट मी टेल यू देयर इज अ डिग्री ऑफ मिसपरसेप्शन, डायरेक्ट प्यूनिटिव एक्शन, डायरेक्ट, देयर इज नॉट अ सिंगल प्रोविजन इन लॉ। वो जो देखें जो वायलेशन 2A ये जो फिलिंग है, वो इन सिचुएशन ऑफ इफ़ यू डू नॉट इंक्वायर फ्रॉम द पार्टीज एंड डू नॉट फिल ऑल द कॉलम्स, उसकी हुई ना, ठीक है। दूसरी क्या प्यूनिटिव प्रोविजन है कि इफ मैरिज सोलेमनाइज्ड बाय समवन अदर देन द रजिस्ट्रार एंड इफ ही डज नॉट रिपोर्ट टू रजिस्ट्रार फॉर पर्पसेस ऑफ रजिस्ट्रेशन, तीसरी कोई नहीं है, ठीक है। अब किडनैपिंग या कोर्सन, उसमें आप किस क्या करेंगे, इसको क्रिमिनल कॉन्स्पिरेसी में ले आएंगे, मुआवनत अबैटमेंट में ले आएंगे, ये तो हालात और उस पर डिटेल करेगा। तो एज सच इतनी बड़ी जिम्मेदारी उस पर ना दें। एज द ट्रेनिंग इज़ गोइंग ऑन कि दे नीड टू नो वेरी क्लियरली। फॉर इंस्टेंस ये तो आप ज़रूर बता सकते हैं ना कि बाबा ये ऐसी नई शर्त लिख देनी, ये वटे सटे की या कम उम्र के जी ये होगा कि जो सरासर जो फॉर इंस्टेंस ये लिख दे कि किसी थर्ड पार्टीज़ के राइट्स को इम्पीच करे, देयर मे बी सम लायबिलिटी ओवर देयर, लेकिन वो इनडायरेक्ट आएगी। हम जो कह रहे हैं ना कि जी सीधा पकड़ दकड़, आज तक मुझे बताएं निकाह रजिस्ट्रारों के कोई एक आधा जस्टिस रमदे के टाए चढ़ गया था एक रेट में और उसने 12 साल की शादी रजिस्टर की, दैट्स वेरी ओल्ड केस 95। वो भी उसने डीसी कंसर्न से कहा कि इसकी इंक्वायरी करो, लाइसेंस कैंसिल करो, ठीक है। या निकाह रजिस्ट्रार कहाँ धरे जाते हैं, अगवा वाली शादियों में, पर्चे में आ जाते हैं बराह रास्त, राइट, उसमें आ जाएं। बाकी जो जितना बाकी पार्टीज़ पे जिम्मेदारी थी उसमें कहा जी ये भी बेची सी, या ही न्यू सो ही अबेटेड इन हैपनिंग ऑफ दिस मैरिज, राइट, तो वो हो जाता है। इसी तरह से आई रिमाइंड यू ऑफ शेख इजाज़ निसार्स जजमेंट विच ही रिपीटेड ट्वाइस। एक तो वो आलिया आपको याद होगा, यू मस्ट बी अटेंडिंग दैट कोर्स, वो आप एक वो मजूर बंदा था, एक 14 साल की बच्ची से शादी की हुई थी, उसमें उसने रिपीट किया था, और उससे पहले भी कि जी अगर मिस्टीरियस सर्कमस्टांसिस में शादी हो रही हो तो सोलेमनाइजर इफ़ ही आल्सो हैपन्स टू बी रजिस्ट्रार, इट्स हिज ड्यूटी के उम्रें चेक करे, कंसेंट चेक करे, पता करे कोई हेरा फेरी तो नहीं हो रही, एंड ही विल बी हेल्ड रिस्पॉन्सिबल फॉर एनी सिविल और क्रिमिनल लायबिलिटी। हाँ, ये इजाज़ निसार ने अपनी एक अर्लियर जजमेंट को रिपीट करते हुए उसमें ये लंबा ऑर्डर दिया था, लेकिन बाकी को ना कल उन्होंने फाड़ लिए तो यार ऊंज नहीं काम होता।
One of the things that's been interesting about this project is seeing how there's this divergence between kind of what happens in the law and what happens in practice. And so the comments that you've just been making about what can they be held responsible for, what they can not be held responsible for, is one really important aspect of it. And it seems like that registrars that we've got data from so far in this project is how many of them are playing a role outside of and well beyond that, in the sense that it's definitely not their official role to advise people how to, you know, whether they should give the right of delegated divorce or how much dowry they should be giving. They're supposed to just be facilitators, but in fact we see that a large proportion, if not the majority of them, are actually doing that in practice, and so that makes their role even more important. So it may not be possible, you know, there's not really a carrot, there's not really a stick that can be held over them over what they decide to do in some aspects of this, but definitely raising their awareness on those, you know, on this broader set of issues on which they advise seems like a really important thing to do.
You know that when they don't know their responsibility, well, at least I can say them would be those who don't know their responsibility and hence are making mistakes inadvertently. The example is when, I think we have all talked about it, when one of the nikah registrars during the training resigned because he didn't realize that his responsibility was so great. So he actually resigned during the training. He said, I didn't realize that. वैसे वाकई में. So goes to tell you that people don't understand the magnitude of this responsibility. So, I think at this, okay, Ji, quick.
It's fine, I'll just subsume it. So I just wanted to ask, given the whole situation regarding education of the registrars and awareness of the women and everything, obviously we have to go a long way. So do you suggest right now in this situation to women to have legal assistant with them to fill it out, or?
ने बंदे डालोगे बात सुने एक थोड़ी सी, देखिए हमारी जो औरतें दो साथी यहाँ बैठी हैं, there is a disadvantage to women. Why they do not know these details? Because this thing happens on the man's side. और वहाँ पे जितना वक्त पड़ता है, लिटरली सारे फिलासफर आ जाते हैं, और जितने बुजुर्ग होते हैं और जिनको RSVP लिखा होता है ना निकाह पे, वो सारे RSVP जो गंद मारते हैं, पहला सवाल पूछे, हाँ जी गवाह, वो जी दो वालों की तरफ से, दो लड़कों की तरफ से, मैं कहता हूँ उन्होंने लिखांगे किथे, उत्थे तो दो दी जगह है. सो डू नॉट, इट्स नॉट, इतना घबराएं नहीं, ठीक है. हमने तो देखे इन्होंने कितने हज़ार रजिस्ट्रार्स की ट्रेनिंग का पेश किया. आई गेव यू समरी ऑफ 100 years केस लॉ ऑफ द सब कॉन्टिनेंट, राइट. सो आई मीन देयर आर थिंग्स के की इशू के ये पॉइंट कंटेंशियस है, या 100 साल पहले होता था, नहीं होता था, तो उससे इतना ना डरें. दूसरी बात, दोज हु आर मैरिड मैन एंड वीमेन, गो होम, look at your nikahnamas. There is still time to revise that. Conditions revise हो सकती हैं. There is no bar. आलिया बैठी है पंजाब कमीशन में. आलिया सारे दी हाज़री ला, वजीर भी है, कहा जी जिन्हें जिन्हें आना है AGHS.
On another note, ये awareness का मसला होता है और interest का मसला होता है. And I'll give you my own example. 30 years ago, when I was getting married, a friend of mine said, you know, there is a delegated right of divorce नाम की कोई चीज़. So I said, what is it? And in simple language, he says, this way you can decide to divorce your husband, and there's going to be reduced legal process, and it's going to be much easier. So I said, okay, fine. I spoke with my husband, and he said, अच्छा ये क्या चीज़ है? We had a discussion before the marriage, and I ended up taking it. ये और बात है कि निकाह रजिस्ट्रार ने कहा कि मैं नहीं पढ़ाता नहीं निकाह जिसमें ये गैर इस्लामी हरकत हो रही है. But it was, I did not need to have a law degree. मेरे पास है ना. So I fought with him. And I said, you are going to do as I tell you and not what you tell me to do, you know. So I had that.
I think it's also worth pointing out. So I think that there was part of the discussion earlier highlighted the difficulty of bringing these things up, and this is something that many of the registrars also shared as a point of feedback from the training, that it would be beneficial for them as well as for the parties concerned if it's filled in advance and not filled in right before. Yeah, and so it's obviously a really contentious, potentially sort of stressful and contentious situation to ask for these things, which makes it all the more important that there's more kind of lead time in informing the women in particular, but informing generally all the parties about what kinds of decisions they have to make. So for example, I'll tell you one example. I told a colleague about this project, and she said, oh, you know, when I got married, we were getting ready to get married, my husband and I, we actually, there was like the two sides, the in-laws were kind of sitting together, and they were filling out what's going to be in here, and they were filling it out, and I sat, and she had a love marriage, and she said, I was texting my husband-to-be, my fiancé, and saying, if this is in there, I'm not signing it. She didn't say anything out loud. This is a very empowered, I would consider this a person who's a very empowered sort of a person. She didn't feel that she could say in front of her new in-laws that, okay, no, I don't want to sign this, but she kind of reached out to him and said, can you advocate for me? And then he spoke up and said, no, let's change it. So realistically, I think the process that could end up changing the kind of bargaining here is going to look something more like, you know, she is informed in advance, and she goes and speaks to her mother or to her father in advance and says, you know, I'd like to talk about this. So you start a conversation with somebody who does have more weight in that process, because realistically, the bride is often going to be the one with the least ability to speak up and advocate for herself. So I think we need to think a little bit about how can we
last thing.
how can we get to a situation where that kind of negotiation is possible through bringing in other people as advocates, not just the woman by herself kind of sitting, not being a part of it at all.
And one recommendation, which really practically, no matter what you do with registrars or what you do with elsewhere, also we need to, wherever possible, when other things are decided that where the walima will be, at this be nikah, if it's the same, it's the same city, do it, it's your 2 hours hall booking. If we get into that, it does not happen. Go realistically that wherever possible, people should have the nikah, and it's a growing practice. what you say, that to do in the morning or a day earlier, otherwise no matter what you bring. 11th hour, there are so many cuttings, things, and now I'm speaking from experience having been party to so many nikahs, that things go wrong. So within 2 hours, Maulvi gets 10 minutes and yes. And as there is a growing tendency to Solomon and have nikah in Wazir Khan Masjid, na ke photo shoot achhi hoti hai.
I'm going to close this now
publicize
because I have to be somewhere. Thank you all. We are closing this now, okay?